Bill Henshaw here again, your resident constitutional kook. And another recent current event you've probably seen is the ruling of the 9-0 farts, the Supreme Court, in the Colorado Baker case. And that was a case where the state of Colorado tried to penalize them because they refused service to a gay couple who wanted to buy a wedding cake. Now, where I come from, this is a no-brainer. I mean, especially with a case like this where you have a privately owned business that wants to do business their own way. We're not talking about IBM here. We're not talking about Microsoft. People that are artificial corporate entities that are held to a different quote unquote standard because they're a quote unquote 14th War Amendment citizen. But if you have your own business and whatever limits you want to set on it, and by the way, I wouldn't. To me, it doesn't matter if you open a business and say, "Well, we don't want to serve blacks here or Chicanos or what have you." Doesn't matter. The common law remedy for that is if enough people disagree with you and don't do business with you or take away business they have been doing, you go out of business. That's the way you take care of a problem like that. You don't haul people's ass into the court under the 14th War Amendment, which doesn't exist, and try to claim civil quote unquote rights. Now, unfortunately, in this case, the court made a very brief, what's called a per curiam decision. Not one justice officially signed on to the case. And all they ruled was that the 14th Amendment, as it applied in this case, was overbroad and it was too extreme to be applied in the manner it was by Colorado in this case. What should have been addressed was the real issue here, which to me is the constitutionality of the 14th Amendment, and that's a no brainer. As you'll see, all you people that apply and get my document packets, which you can get at ccaspari@live.com. Very modestly priced documents. You get information for them. Send me an email. I'll tell you all about it. But that's the real point. And the court has the power to go beyond the record. It's not something they do that often, but they have. And a very infamous case in which they did this is called Erie Railroad v. Tompkins, Tompkins, 304 US 64. And what happened there was that the court, I think was 6-3, but however they decided, it was written by Brandeis, I'm pretty sure, Louis D. Brandeis. And he opened up the case by saying, well, we're going to do something here that neither party has requested us to do, and we're going to hold unconstitutional the decision that the court made 96 years ago, a case called Swift v. Tyson, Tyson, which I believe is 142 US 1. And that was a major big deal to overturn a precedent of that longevity, and without either side asking them to do it, without either side putting in legal briefs to argue the issue one way or another, they did this. And it was a major big deal because Harry Tompkins, who was the victim in this case, it's a long story about that, but trust me, he lost a $30,000 verdict against Erie Railroad that he shouldn't have lost. And he won it in state court where there was more or less strict liability for what the railroad did, but the railroad tried to remove it to federal court where the reference standard was quite a bit different. Now, this is a really big deal because had the proper arguments been made by Tompkins' attorney in the trial court, and this is 1935, when you might think these arguments would have been made, Erie Railroad is a corporation, a 14th Amendment citizen, if that amendment exists, which it doesn't. They don't have the power to remove any case at all from a state court, let alone moving it into a federal court that's exercising admiralty jurisdiction. It just doesn't exist, and that's the sort of issue that should have been decided by the court. If they wanted to go outside the record, that would have been not only a hell of an opportunity to do it, but doing it at a time during the New Deal administration of fascist dictator Roosevelt that we could have had some meaningful decisions made there. And by the way, I'll note for the record, in my opinion, the New Deal, it would have been real nice if they told us all they were doing was using a deck full of jokers. Damn. But that said, to do that in a case of that type, and by the way, a little further note, if you want to do some more studying on it, the cases they cited, more recent cases to reverse this case, were called brown and white taxicab versus black and yellow taxicab back in around 1915. Corporations And one of them invoked diversity jurisdiction based on state citizenship, which you can't do as a 14th War Amendment citizen, and got a very controversial ruling against the other taxi cab case. It was a BS case. The court should never have taken it in the first instance. By the way, if you want a citation on that one, send me an email at ccaspari@live.com. I don't have that citation off the top of my head. And yeah, I know that's amazing, but there are a few that I don't know, and that's one of them. But send me an email, I'll get it to you. You can look at that case and read it in the context of what later happened in Erie. And by the way, another interesting device that happened contemporaneous with Erie in 1938. Well, I think they were decided just before, but that was when the Congress created the Federal Rules of Civil Procedure, and they combined, which you can't do, the courts of law and equity. You can't do that. They're two different jurisdictions. So we don't have any common law courts. That's one reason, by the way, that I'm saying that not only can a corporation not remove a case from a state court of common law general jurisdiction, which we're supposed to have and which the Constitution mandates, they can't remove it into a federal legislative tribunal. They can't do it. And yet no one makes that argument because, for the most part, they didn't teach me in school, they didn't teach you in school either. And the attorneys who may know this, and I'm willing to bet you there are some, especially in the world of corporate attorneys that went to Harvard, Yale, whatever, and do learn this knowledge, they keep it carefully concealed. And only if they would have a good reason to bring it out in the open and threaten somebody in the government to make it public would that come out. I mean, nobody knows. That's what I'm getting out there trying to teach and say, hey, people, it's not that hard. It's not going to take you 4 decades to learn it like it took me. You get my documents and read them, go over them closely, the 5 basic documents in particular. You have a real good handle on these issues, and you will be so far ahead of the dumbass and even the trial judge that you're probably going to get the charges dismissed, and they might have a lot of hesitation in the future about charging you with anything. If you can put up a real fight and know how to invoke your rights secured by the Constitution, that's the best gift I can give you. That's what the Constitution set up, and that's how you do it, and you beat the bastards. Thank you.